Case number 116430, State of Kansas v. Derek Campbell.
May it please the court, counsel. It was Corey Call, appellate defender representing Derek Campbell. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Derek Campbell shot and killed his wife. That was never disputed. He testified that he came home and he had a concealed carry gun, and it was a revolver. He shook the bullets out of the cylinder, then closed it, and was dry firing the gun, and there actually was one bullet left in the chamber. On the third squeeze, it shot and killed his wife.
That was the second recitation. That was
That's-
his second version. His first version was that we had an accidental fire as he drew it from the...
That's right. That was what I said was what he testified to at trial, and he told the police that it was an accident, so he pulled it out in the first. The state argued that it was an intentional, premeditated killing, and that he shot her, that he wanted a divorce, she wouldn't give him one, and so he shot and killed her.
Mr. Call, did the evidence about the detective kind of testing the gun and different types of bullets in the gun come in before the jury? That there were these three different kinds of run-throughs of shaking them out, and then one time one stuck, and the next time none stuck, and the third time three stuck?
I don't remember that specific. I remember that testimony, and I believe that it did, but I can't say for certain. I apologize. But I remember that testimony, but I don't recall whether it was an aside or not. I believe it did.
Thanks.
So the state's star witness, because the question was, did he intentionally shoot the gun or was it an accident? That was the question for the jury. The state's star witness was jailhouse snitch extraordinaire Ronnie Rudisell, and he testified that he was in the Sedgwick County Jail with Mr. Campbell, and Mr. Campbell told him that he intentionally shot his wife. And the defense cross-examined him, pointed out that he had convictions for forgery, impeaching his credibility. So at that point, the state was allowed to present opinion testimony about his credibility. So to that end, they brought in Assistant U.S. Attorney Tara Moorhead, who testified that she had worked with Mr. Rudisell on 3 occasions and had found him to be credible on each of those occasions. The problem is that a character trait like credibility cannot be proved by talking about specific instances of conduct. Now, the initial question for this court, I think the state raised, that this wasn't preserved, this wasn't objected to below. And the state, the day before Ms. Moore had testified, they brought up this and the court discussed that. And the defense objected on that he was vouching, that this witness would be vouching for the credibility, be bolstering her credibility, and that it was hearsay. And I think that this falls under the umbrella of bolstering the defendant's credibility. That's the challenge we're making. But more specifically, at the end of that hearing, the defense counsel says, I want to object to this, but I don't want to go through it. And the judge says, he says, the defense counsel says, I want to object based upon our discussions with you. And the judge says, okay, well, make a statement, don't go into detail, but make your objection, I'll give you a continuing objection. That's pretty much what happened. Right before she testified, defense counsel says, I renew for purposes of the record all the objections that I had to her testimony and which we discussed on the record yesterday. So the question is, did they discuss specific instances of conduct? And going back to the day before, on page 92 of volume 18, the prosecutor says that she'll give an opinion, that he's credible, and I would not seek to get her to give specific instances of why she believes that, because those would be inadmissible. So defense counsel objects based upon our discussions yesterday. Yesterday they discussed the specific instances of conduct were inadmissible. At that point, it was preserved. So her testimony was that I met Mr. Rudisil, and he was an informant on this one case, and that he testified, and then there was another time when she was prosecuting him, and he had some information, and then later on in that case, he had some information on another case. And each of those is a specific instance when she dealt with him and she found him to be credible. And that's exactly what is prohibited by the statute, and for the exact reason of what happened. The reason we don't do that is because what you don't want is for the trial to devolve into sort of mini trials on these separate issues. So what happens on cross-examination? Defense counsel, who was really pretty reserved in the matter, gets up and says, well, when you met with him on this first case, how many times did you meet with him? How long was each of those meetings? What are we doing? We're in a murder trial, and we're talking about the minutia of when this witness was discussing another case with Mr. Rudisil. That's why we don't have the rule. And so in that case, her testimony, she just had these 3 instances to do it, and I struggled with this a little bit because the problem was that the state, once the defense impeached the credibility, the state was allowed to bring in opinion testimony. And certainly Ms. Moorhead couldn't just come up and say,
You got to lay the foundation, right?
You got to lay the foundation.
So that's where I was struggling with. The statute appears to have some internal tension, if you will, between laying foundation for proper opinion testimony versus talking about specific instances.
Exactly.
And so how are we supposed to navigate that?
Here's the answer, I think, is that if your relationship with the witness is so minimal that in order to establish foundation, you have to address specific instances of conduct, then you cannot testify about the opinion.
Well, let me ask you this hypothetical. Let's say that the testimony had been essentially as follows. Do you have an opinion about this witness's credibility? Or, yes, I do have an opinion. Well, how did you form that opinion? Well, I worked with him on 3 different occasions. And, well, what is your opinion? Well, my opinion is that he's credible. Would that be objectionable?
I think it would be. And I don't know where.
So how do you ever get an opinion in evidence then?
Well,
if that's objectionable.
Sure. Well, I think normally how this comes about is, well, I've lived next to Bob for 20 years.
Yeah, I was just going to say, they're my best friend.
Yeah, my best friend, my Uncle Joe, I've known him. He is credible. So there's no specific instance. And when you said these 3 occasions, you're still sort of referencing, I dealt with, he was credible on this occasion, and this occasion, therefore I think he is credible.
So if the answer is, well, I work with him, that's okay. But if I've worked with him 3 times, that's not okay. Is that the line you're drawing?
It is the line of drawing, but I think that you would have to flesh it out a little bit more to where if you said, well, I work with him. Well, how many times did you work with him? Well, I worked with him once. Okay, well, that's no good, right?
He's been my jailhouse snitch before.
Yeah, that's right. Yeah, I've been prosecuting this guy for 20 years. In every case, he comes to me with information. That's a different deal. But if you have to rely on, if the foundation is based upon individual specific instances, then the statute prevents it.
But it's always based on that, even if you've been best friends for 20 years. I mean, a good cross-examiner could delve into that. Well, how many years have you been friends? Well, how often do you see each? I mean, at some level, these opinions are always built on accumulations of specific instances.
I think that's true, but I think at some point the individual specific instances become part of a larger whole. I mean, I don't trust my wife because of a specific instance. I trust her because I've known her for 30 years, and it just exists, and I think that's what the statute was meant to get into. Otherwise, you do get into just what happened here. They devolve into these mini trials of each specific instance. And I don't know, 5, 10,
given that
20?
This is a bit of a hair-splitting exercise, wouldn't the district court be afforded a great deal of discretion in where the district court decides to draw that line? And in this case, the record seems clear that the district court was actually aware of this tension and did its best to draw that line in a reasonable place.
Right. Well, I think at some point it's probably a hair splitting. I do not think it's hair splitting at 3.
So you just say this district court abused its discretion in performing its gatekeeping function to try to ferret this.
That's right, because 3 is, as a matter of law, specific instances. If you want to get into 20, it's like, well, 20, yeah, they were specific instances, but it sort of devolved into an overall opinion as opposed to an opinion on each individual. And I think this is highlighted by the fact that in her testimony, what she said was, I want to get this right, that I believe he was credible on each occasion. I mean, she was making the point, and that was sort of natural because there were only 3 of them. She was making the point that it was each occasion. That's what her opinion was based upon. Not upon her general sense of him, but on each occasion. And so I would say it's, at some point it may be hair splitting. It's not hair splitting at 3. Those are specific instances of conduct.
When she ties them to the occasions. I mean,
That's right. I think that adds
she
to
could
it.
have said, I think he's a stand-up guy.
Well, I think that's difficult because I don't know. The foundation for that would have been, I had these 3. When there was only 3, he's a stand-up guy on the 3 times that I worked with him. That's sort of the implicit, when she says, when she testifies, the foundation, this is why she's credible to give it is, I worked with him here, I worked with him here, I worked with him here, and I think he's credible.
She just should have been more vague about how many times she worked with him.
Well, then I think the defense counsel may have gotten into a little bit of, well, that you can't have that. There's no foundation for your opinion if it's just based on these specific things. I understand what
That's
you're
the
saying.
difficulty my colleagues identified.
Yeah. As far as the harmlessness goes, the state frames this as that, well, she could have testified that he was credible. And so there's not too much of a difference in her saying he was credible and he was incredible on each occasion. And I don't believe that that's the correct harmless error analysis, because we don't look at what a witness could have testified to and what would have happened in the trial if they would have testified properly. We looked at, if this court finds that testimony was improper, all her testimony was he was credible on these occasions. If this court finds that that was improper, then her testimony should go. It's not what would have happened if it would have been right. It was that her testimony is then stricken. And did her stating that Rudisill was credible have an effect on the jury? And the state in their brief talks about the importance of Mr. Rudisill's testimony, that he was the one that said, that's where you got it. He told me it was intentional. That was important testimony. And you have on the stand Assistant U.S. Attorney Tara Moorhead saying he's a credible guy. This isn't just an ordinary witness. This is an Assistant U.S. Attorney who's making this sort of giving her opinion, vouching for his credibility. It's difficult to see where the evidence, where the question was, what's going on in his head? And you have basically a confession coming in from a somewhat suspect source, right? I mean, Mr. Rudisill, the jury would generally view this guy as maybe a little bit questionable, but you have a U.S. attorney, assistant U.S. attorney coming in saying he's credible. It's difficult for me to see how you say that didn't affect the jury's verdict. We would ask you to reverse his convictions.
What evidence was there besides Mr. Rudisill and Tara Moorhead that would suggest this was the crime committed by your client?
It was said when he was approached by the police, he told the police that I was pulling my gun out. So he gave a completely different story initially as opposed to what he told at trial. So you have 2 conflicting versions. You also have this, he was having difficulty, his marriage was troubled, and he wanted a divorce, his wife wouldn't give him a divorce, and that night he had been driving around with his old high school girlfriend. So he'd been driving around with her, and I don't remember there being anything happening beyond that, but certainly talked about trouble with his wife. He mentioned their previous sexual encounters. He seemed to be flirting with someone who was not his wife that very night. And I suppose if I'm forgetting anything, there was a testimony from a witness saying that he was controlling her, and he was very controlling of her. They said he wanted a divorce, she wouldn't give him a divorce.
I guess I don't understand why that isn't contradictory. If he was controlling, but she wouldn't give him a divorce, he obviously wasn't controlling that part of it.
Well, and
And what if you have the ability to control someone else, why you need to kill them to get what you want?
Yeah, I think, and I get it. That was so. The state argued that, and also, the fact that she wouldn't give him a divorce. Well, you can hinder the process, but in the end, you can't. It doesn't take two to tango on getting a divorce. One person wants it. That's what's going to happen. So, but those, I think, the state may more, but those are the ones that stick out. I think that the really big thing, obviously, was Rudicel's testimony was huge. The fact that he gave different stories was, I think, also damaging to him.
And what would have supported sudden quarrel?
Rudisill, actually, he said that he came home. They talked about the divorce. He got angry. They argued. Then he went out, got the gun, came back in, and shot her. And so that was the quarrel. The quarrel was about their divorce, but it came from Rudisill's testimony.
Any further questions? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I will focus on issue 1 and, of course, address any questions on the other issues.
Well, let's start by answering the last thing we talked about. Why wasn't there evidence of a sudden quarrel through the state's witness?
God forbid if that's the standard, because every married person would then be able to shoot their spouse and claim sudden quarrel, because there was nothing sudden about this, and there was nothing beyond a verbal argument. The testimony in this case was that this was an ongoing, unhappy relationship, that the defendant very clearly was looking for a way to get out of the marriage. He had begun researching divorce online. He had begun looking at dating websites, and he had told his girlfriend,
But your argument is there wasn't sufficient provocation to be a sudden quarrel, heat of passion, is what you're saying.
Certainly,
Okay.
yes, yes,
Okay.
yeah. That
I won't
yeah.
belabor that any further. I just
Okay.
wanted you to address that. Thank you.
Now, with respect to issue 1, it is our primary position that this was not properly preserved by a specific objection. What happened here is that at trial, initially, apparently the defense was planning on calling the assistant U.S. attorney to the stand, decided not to, so then there was this discussion about what the state would be able to get into with this witness. The objection that the defense raised below the day before Ms. Moorhead testified was that she should not be allowed to vouch or bolster Rudisill's credibility. On appeal, not only is he not making that argument, but he's conceding that based on the way that the defense attorney had cross-examined Rudisill, that it was appropriate for the for the prosecution to be able to ask questions and get her opinion with respect to his credibility. It's now for the first time on appeal that the defense is ever arguing that the state went about that the wrong way by bringing up specific instances of conduct. Counsel's correct that at the hearing when they were discussing this the day before Moorhead testified, that the prosecutor referenced specific instances by way of telling the court, just so you know, I'm not going to ask about specific instances of conduct because I know that's not appropriate. The defense never mentioned it. So the fact that I don't think that a statement that a prosecutor makes satisfies the defense attorney's burden to lodge a specific objection. He's raising that for the first time on appeal, and our primary position is that as a result, this court should follow King and follow the contemporaneous objection rule of 6405 or 404 and determine that this issue is not properly preserved. Now, of course, I'll also address the merits. If this court chooses to reach them, it is an abuse of discretion standard regarding the admission of evidence. I think the defense brief also cites that standard of review. Our position with respect to the merits is that Moorhead did not reference specific instances of conduct. Instead, she was as general as it gets. When she was asked how she formed her opinion, she said, because he's been credible on each occasion that I've dealt with him. Now, as I thought about this, and the questions that you asked of opposing counsel, I think were spot on. This is kind of a difficult line to draw. But as I thought about analogies for this and scenarios, I thought about the example of perhaps somebody asks me to tell them whether I like a certain restaurant. If I answer that question yes, and they say, well, why? And I say, because every time I've gone there, it's been good. I don't think that's referring to specific instances. Now, on the other hand, if I were to say, because last Friday when I went there, I had the best piece of salmon I've ever eaten and the best waiter I've ever experienced in my life. That's a specific instance of conduct. It doesn't get much more specific. But by contrast, when you're just saying based on all of my previous dealings with this person, that's as general as it gets. That's as far from specific as I can imagine. Now, there's been some discussion. Does it matter whether there have been 2 prior dealings, 3 prior dealings, 20 years of living next door to the person? I would say not, as long as the witness does not specifically refer to any particular interaction that they've had. And so I think that by saying each occasion that Ms. Moorhead was being as generic and as vague and non-specific as possible. So that's our primary position with respect to the merits. I guess my question for defense counsel would be, if his position is that she referred to specific instances of conduct, identify one such specific instance that Moorhead testified about. I don't think that he'll be able to do that because she simply did not offer that type of testimony. Counsel mentioned that in the case law talking about this, the reason why you don't allow specific instances is because you don't want to turn it into this mini trial. I quoted State versus Hall on page 15 of my brief, and that's where this court talked about you don't want the trial to go off on, quote, collateral tangents. I certainly don't think that her testimony got anywhere close to that line here. Again, I would argue just the opposite, that what she did was as general and non-specific as possible. If this court disagrees with that, of course, our argument would then be that the testimony constituted harmless error. The test would be whether there is a reasonable probability that it affected the outcome in light of the entire record. First, I would just say that adding the words "on each occasion" to testimony that the defendant himself acknowledges was otherwise admissible. Again, he's acknowledging that based on the way that the defense attorney had cross-examined Rudisill, that it was appropriate and allowable for the prosecution to be able to cross-examine or to question Moorhead about her opinion with respect to credibility. So I don't think that just adding the phrase "on each occasion" to otherwise proper testimony affected the outcome of the trial.
What's the difference between her opinion that he's credible and her opinion that he's extremely credible? Because her testimony was he was extremely credible.
I don't know that there would be a difference.
Can you be? I mean, is it like pregnancy, or is it? I mean, I'm trying to see if she didn't put her thumb on the scale here. And these are talented people that are up testifying here. They're prosecutors. They know where the lines are drawn, and they're trying to stay as close as they can to the line. And this seems to be going a little too far.
Well, I think with respect to that analogy, I would say that with credibility, yes, there is a scale on it. I don't think that the pregnancy analogy is quite. I would submit that probably everybody in their life has at some point told an untruth. But we still consider many people to be varying degrees of credible. So I don't think that saying extremely is a problem, and I certainly don't think the defense has challenged that. To the extent that evidence or that testimony might weigh more strongly in the state's favor, I guess I don't think that makes it improper when she does have a basis for testifying to that based on her interactions with the defendant, and she is testifying with respect to her opinion. Now, back to the harmless error. As far as the strength of the state's evidence, we do, of course, have the defendant's statement to Rudisill in which he did confess that the shooting was, in fact, intentional, contrary to the other 3 versions that he gave at various points in this case. We also have his ongoing comments to his prior girlfriend, the woman that he was driving around with that night, not only had he told her in person that night about the state of his marriage, and not only had he been complaining about his wife, but he had also been sending these Facebook Messenger messages to her in which he had again reiterated on how unhappy he was. He had done the research about divorce. He was looking at these dating websites. While, of course, those don't in and of themselves prove that the shooting was intentional, I think they do provide some evidence going toward that, and they certainly would establish motive. Our position is that he was very unhappy. He was controlling, and for whatever reason, I don't know why he wasn't smart enough to realize that you don't need your wife's consent to get a divorce, but apparently that was a concept that was lost on him, and he seemed to be struggling with that. And so rather than simply filing for divorce, he continued to complain about it. And our position is that ultimately, on the night in question, he reached his boiling point, and at that point, his final attempt, I guess, to kind of maintain control of things was to, unfortunately, shoot his wife. Finally, I think, as the prosecutor pointed out in closing argument, that his trial testimony with respect to how this shooting happened simply wasn't consistent with the physical evidence. And obviously the record will show exactly what that bears out, but I think she was referring specifically to just the angle that the bullet, I think, entered. He gave these different stories at various points about how exactly this accidental discharge supposedly happened, but I think he could never, and I remember the prosecutor cross-examining him at pretty great length to point out that his story simply didn't match up with where he was claimed to have been and how this was allegedly happening. Didn't match where this bullet entered and the angle and things of that nature. So I think that there's extensive evidence supporting the fact that this was an intentional shooting, including his own statement to Rudisill.
If you take out Ms. Moorhead's testimony as being error, how can you leave Rudisill's testimony intact? Because she basically was saying he is a credible guy. I've worked with him as an assistant U.S. attorney on some occasions. I think she said 3.
Yeah, I think there were 3 total cases.
And on each instance, he's been extremely credible. So, not to disparage Mr. Rudisill, but he doesn't have a sterling reputation coming in to testify. I think defense counsel pointed out the forgery conviction and the fact that he was in jail on other charges. I mean, how do you separate her testimony from his? And if you cannot, then you're left with the prior girlfriend's testimony, and then his inconsistent statements about how this happened, and then how his statements were inconsistent with the physical evidence.
Well, I think even without her testimony, obviously the jury is always told that it's their role to determine witness credibility. And as you pointed out, defense counsel had brought out Rudisill's past. That's essentially why the state put Moorhead on, was because the defense attorney had highlighted Rudisill's criminal history and some of these prior offenses that he had. They knew that he was a jailhouse informant. So the jury clearly was able to still assess that in their own eyes. And I think that while I certainly don't disagree that having Moorhead testify was helpful to the state. Obviously, that's why you put any witness on, is because you think that they're going to be able to bolster your case. But on the other hand, I think it would be going too far to believe that the jury simply was rubber stamping this, and that once they heard Moorhead's opinion, that they simply shut down and thought, well, you know what, otherwise I would have questioned this guy, but because a state's witness has gotten up here and said that she finds him to be credible, then I'm not even going to make an independent determination on that. No different than, obviously, in just about every case, the state has police officers testify. I would argue that for a lot of jurors, a lot of people, that law enforcement officers do carry some sort of authority, much the same way that you could argue that Miss Moorhead did as an assistant U.S. attorney. And yet, we see all the time that there are not guilty verdicts, which would suggest that the jurors don't just automatically believe something that is being testified to just because it's coming from a particular source that might be seen as a pro-prosecution or as an authority figure. So I don't think that you just have to say, well, if we think that her testimony was improper, then we just have to completely throw out Rudisill's testimony and act as if it didn't exist. You still have to go through the analysis and recognize that the jury was aware of his character flaws and his potential credibility issues. They were told that it was up to them to make that determination, which I would say then, because you presume that the jury follows the instructions, you have to presume that they did, in fact, make their own credibility determination, and they didn't simply let Ms. Moorhead do that for them.
And what is our standard for reviewing that question of harmlessness on this case?
Whether there was a reasonable probability that it affected the outcome in light of the entire record. And our position, of course, would be that there is no such reasonable probability in light of all of the evidence that we've discussed. So again, in order just to sum up, our position is that this issue is not properly preserved. If this court disagrees with that position, our argument would be that she did not reference specific instances of conduct, and therefore his argument fails on the merits. And as a third argument, it would be that any error that did occur was harmless in light of the record as a whole. I see that I'm out of time. I'd be happy to answer any further questions, but if there are none, we would simply request that the defendant's conviction be affirmed.
Any more questions? Thank you, counsel.
Well, the state said that I should get up here and tell you what the specific things that she talked about were. So, let's look at volume 19, page 60. It's about a page and a half, so bear with me. The prosecutor is asking her how she knew Ronnie Rudisill. I first became aware of Ronnie Rudisill when I handled a case that was assigned to me. It came to me from Leavenworth Police Department. It was kind of a standard case, gun and drug case, and he ended up being a witness in that case. Do you have a particular type of witness? He was a confidential, what we call a confidential informant, or cooperative witness. He was involved in helping police do an undercover buy of drugs. As a cooperating individual, did he get a benefit for his testimony in that case? Not from me. He did in connection with a state case that Leavenworth County was handling at that time. Did he actually testify in the case you were prosecuting? He did. He testified against the individual whom he had bought drugs from. That incident was captured on both audio and video, but he did testify in a jury trial. After that, did you have another case? We provided information. I did. How many total cases? There were a total of 3 separate occasions at 3 separate times. And did he ultimately end up testifying in each of those 3 cases? He testified in the first one that I mentioned, and then the third one. He did not have to in the second one. His information was used in another case, but that case resolved by way of a plea, so he didn't actually have to testify. Well, that seems pretty specific to me. I mean, you're talking about this was a gun and drug case, one that he testified that she said there was in one case there was captured on both audio and video, but he testified in the jury case. This isn't just general. Yeah, I know him. This is when she gets into the actual details of the cases. That's specific right there. So if you want it, volume 19, page 60-61.
Any further presentation?
No, thank you.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. Turn to the 4th case on this morning's docket, case number 115834, State of Kansas v. Jonell Lloyd.
May it please the court, Clayton J. Perkins of the Kansas Appellate Defender's Office appears on behalf of the defendant appellant Jonell K. Lloyd. I would request 3 minutes for rebuttal.
3 minutes is granted.
In way of brief factual and procedural summary of this case, Mr. Lloyd was convicted in 2009 of premeditated first-degree murder, felony murder, and child abuse of his 17-month-old daughter, who I will refer to as CB by her initials. In his appeal after his conviction, the district court imposed a hard 50 life sentence with a possibility of parole after 50 years through the enhancement procedure allowed by the district court at that time. During his initial appeal, the United States Supreme Court's Elaine case came out, and because of that, on his appeal, his hard 50 sentence was vacated and remanded because the sentencing factors had to be found by a jury. During that appeal, he also raised a issue about the voluntariness of the only witness in the cases, the only direct witness in the cases' statements and testimony that was not properly preserved for purposes of appeal. Once the case was remanded back, the state filed notice of intent that it would be seeking a new hard 50 jury trial. And so this appeal comes from the hard 50 sentencing trial, where the only points before the jury were whether or not he had, there were 2 aggravating factors present, whether he had a previous conviction for inflicting great bodily harm, disfigurement, or other descriptors, and whether it was heinous, atrocious, and cruel, and finally whether or not the presence of those aggravating factors was not outweighed by the presence of mitigating factors. And that brings us to the first issue we raised on appeal, which is the basically re-raising of the point that was brought up in his very first appeal.
And if it wasn't properly preserved then, what resurrects it now?
Well, I believe first the statutory authority in these resentencing trials, which limits the rules of evidence from basically the rules of evidence don't apply, and the only rule of inadmissibility is whether or not the evidence was obtained through some sort of constitutional violation. And because this is a 14th Amendment due process violation, I think that can come up now. I don't know, given the weird specific procedural nature in this, I don't know if anyone would ever be trying to raise a suppression issue for the first time before the sentencing phase normally. But it came up here because it never came up before. I understand the state's argument has a fair number of procedural issues with the way this was preserved. The analysis that we laid out in the brief is basically takes one, whether or not her Miss Loudermilk's initial statements during police interrogation were coerced, and then asks whether or not that coercion continued throughout her testimony. The state's argument regarding that preservation, I believe, is basically we preserved only an objection to her subsequent testimony, but not her initial confession, which I think the two are so highly interrelated and the analysis is the same that I don't know how you could even get to the second point, whether or not her testimony was impermissible.
But there is a significant factual difference, timing difference between what she said prior to trial and what she said at trial. And that is that the Sink case had been filed, that ship had sailed, what she'd been threatened with in her original statements was no longer a threat by the time she gave her trial testimony, right? So that distinction might mean something to us.
Yes, that distinction does mean something, although I would disagree that the ship had sailed at that point because again, we don't have the record from the Sink case because those are a separate case and confidential, but my reading of the record is there's some statements on there that the Sink case was ongoing, and maybe it had been filed, but the primary concern here is that the state was both calling her to testify about this initial coerced statement that was coerced based on many statements involving the custody of her children, how officers were going to help her, how they were going to take away those children. And then throughout the trial and the preliminary hearing before that and then the trial, the state was basically going through the court proceedings to take those children away.
Okay, so it's your understanding the Sink proceeding was still pending at the time of her trial testimony?
Yes.
Okay,
yes.
thank you.
And was it the crossing? You're complaining that basically that all the statements made by Ms. Loudermilk were coerced.
Yes.
Wasn't and she's a witness in the case, not the defendant, and as the district court judge pointed out, there is a distinction between the right that's being asserted here based upon involuntariness. For a defendant, you're getting the Fifth Amendment types of concerns, and here I guess it's more of a due process kind of concern on behalf of your client. Mm-hmm. And that was pointed out by the trial judge. I guess basically what and those statements about the coercion were specifically addressed in cross-examination by defense counsel at preliminary hearing. Mm-hmm. Why doesn't that get to the voluntariness of those statements? And that's the mechanism by which the procedure was satisfied. There was extensive cross-examination regarding the police action. Is she being coerced to testify then, or to make a statement then? Is she being coerced now? That inquiry was made at preliminary hearing, wasn't it?
Yes, and there was additional cross at trial about it.
Right.
And
so why doesn't that cure the problem that you're having with this? Is that it was the voluntariness finding, or the jury could certainly weigh that at that time?
Because the jury weight might be a slightly different question, but
it's a credibility determination about whether she's testifying truthfully.
Yes.
And the inquiry was made about the very factors that you're concerned about.
Yes, and the inquiry, I would argue, supports the fact that this was coerced testimony. She described that she had these ongoing cases and that she was under the understanding from her caseworker, at least, and possibly the district attorney's office.
But the questions were asked that, are you testifying truthfully? Did that have anything to do with your impression of what occurred on the day in question? I mean, she said no. The fact that I was made aware of what could happen with my child did not enter into what I'm testifying in today. I mean, wasn't that what she said?
I believe she may have said those statements. She also, I believe, said that she was only there because of either the subpoena or these ongoing other cases.
She's a witness. She's there because she was subpoenaed.
Yes. Yeah. Well, that is true. But
she didn't show up for the subsequent jury trial.
And regarding the sort of procedural coercion of an ongoing child custody case, I think that does say a lot. That 5 years later, by the time that case was certainly over with, that she did not appear.
But isn't that two questions, whether her appearance was coerced or whether her testimony was coerced? She could be there under threat of some adverse action in the sink and still tell the truth.
And that is true. I
think that's what my colleague is getting at, is that was tested in the crucible of cross-examination on the truth, and so why shouldn't we give credence to that?
And I think it's because of the inherent coercive nature of this whole process, coming from those initial statements to the ongoing sink case to the reality that what would happen if she got up on the stand and said something other than what she had told the police officers, because she was already arrested originally for obstruction for saying something that the police officers took as a false statement. So when in this particular instance, what is she even going to do? If her testimony was untrue, or her statements during the interrogation are untrue, she's looking for some sort of obstruction charge that they already threatened her with once. Unless the court has more questions on this.
Did you argue anywhere that the in your briefing, I didn't see it, where the statutory factor that the crime was committed in an especially heinous or atrocious, cruel manner, you didn't appeal that?
No, it didn't challenge the sufficiency of that.
Sufficiency of that finding, okay.
Yes. I would briefly like to discuss the sufficiency of the prior conviction.
Why does it matter once there's a finding that if there is a finding that it was especially heinous, atrocious, or cruel, doesn't it just take one of the aggravating factors?
Not under this statutory procedure, because the jury has to find that the aggravating factors are present and not outweighed. This statutory procedure asks the jury to do a balancing of the aggravating factors that were present versus the mitigating factors, and then they have to come out with their verdict.
So your argument is the presence of two aggravating factors may not have been outweighed, but perhaps the jury would have decided differently if they only had to weigh one aggravating against the mitigators. Is that your argument?
Absolutely, yes. And I think the aggravating factor of the prior conviction has to be something that's a factor to the jury, or else the state wouldn't have put it before the jury.
And what were the mitigators here?
The mitigators were Mr. Lloyd's history of abuse as a child, that he was put through a great deal of abuse, and that even there was a witness who was his counselor during some, I believe, juvenile proceedings, that basically said when she got to his case at a very young age, it was obvious that he had already been through a great deal of abuse and was troubled. But regarding that particular factor, the crux of my argument is that it's an assault conviction, and you don't inflict bodily harm during an assault conviction. They're pretty exclusive in that regard. This wasn't a battery, and
Isn't the aggravating factor commission of a felony which results in great bodily harm? It doesn't say that the statutory elements of that crime has to satisfy great bodily harm. It says as a result of the commission of the felony.
I thought
We don't go to the specific elements, do we, or do we?
I think we do. I think that there are sort of two sets of cases. There are cases where you're going to deal with crimes that involve inflicting bodily harm, and then implicitly, whether it's an aggravated battery
So
or
in this
murder,
case,
something
aggravated
else.
assault can never result in satisfying that factor.
No, because it's not a crime where you're convicted of any physical contact. Or,
And that's your argument?
yes, that is mine. And to briefly touch on my last one, I understand this court has already ruled on the ex post facto issue. I'd be happy to answer any questions about my briefing on it, but otherwise, unless this court wants to revisit that issue, I understand it's.
Do you have any rebuttal to the rationale of those cases that have found it does not violate ex post facto?
My argument, honestly, is pretty much the same as in those cases, that you're finding new elements. But I know that has already been addressed.
Any more questions?
Factual question as to the harmlessness on that first issue. Did the detectives who took Ms. Loudermilk's statement testify at the sentencing hearing on remand?
Detective Lenny Rose, I believe, testified. I don't think the other
About
ones.
her statements?
Yes,
Did he testify about her statements? And was there a contemporaneous objection to his testimony?
There was not one lodged before. The defense counsel got a continuing objection.
It was afterwards, right? Did he move to strike, or was there, go ahead, was there an objection at all?
Well, it came up at basically the start of the trial that day, when it was sure that Miss Loudermilk was going to be unavailable. They addressed all of the various issues. I believe defense counsel then asked for a continuing objection, and then I think when Miss Loudermilk testified, the district court reminded defense counsel to object again.
Was that earlier objection broad enough to cover the detective's testimony?
I think it has to be, given the analysis going on with this issue, that you basically can't get to this issue without those other statements being initially coerced.
But there was no objection at the time they initially testified prior to the Ms. Loudermilk's testimony being read. That's right.
There was a continuing objection that was granted.
Specifically to the officer's testimony?
No, I don't think it did address the officer's testimony specifically.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The first issue before the court challenges the district court's admission of Tamika Loudermilk's testimony at the time of resentencing. In order to obtain the relief requested, the defendant has the burden to establish that there was improper coercion during the investigative portion, and that coercion necessarily carried over to taint her testimony to make it unreliable. From a preservation perspective, I think this case is a little bit nuanced. Before the district court, the defendant argued against the admissibility of Loudermilk's trial testimony only, asserting that there was a deficiency in the reliability of that testimony because at the time she testified, she was suffering residual duress. The district court rejected the argument, finding that to the extent she felt pressured at the time of her investigation, that issue was no longer present at the time she testified because those sync proceedings had already been initiated. It subsequently came out through the reading of Loudermilk's testimony on volume 9, pages 86 and 88. She specifically testified, those cases are concluded, and I no longer have custody of my children. Before this court, the defendant places a more substantial focus on the coerciveness of the investigative questions that were asked. But during the resentencing proceeding, counsel for defendant specifically stated her testimony is unreliable, and then in preserving the objection, he said, I'm specifically asking that that testimony be kept out. The defendant is free to argue a violation of his due process based upon a third-party witness's coercion if he can show that the trial testimony was actually coerced and rendered unreliable by a prior coercion. That burden hasn't been satisfied here. Before the district court, there was not evidence offered. There wasn't a proffer made that tended to demonstrate that Tamika was subject to coercion at the time of her investigative statements. A proffer likewise was not made to substantiate a claim that ongoing coercion existed at the time that she testified. Rather, counsel simply asserted she was under duress from that previous investigation. Well, those conclusory statements don't satisfy the burden. Accordingly, the only portion of the inquiry that's properly before this court is whether the district court erred when it kept out Tamika's testimony. And when that analysis is conducted, the district court ruling should be affirmed because there is no indication of duress. Tamika specifically testified that the allegation of duress focuses on her children. Tamika specifically testified that issue does not remain. The cases are concluded and the children are no longer in my custody.
Did she have prior statements, though? Had she already made statements that if she changed her story at trial, that she would be subject to personal criminal acts?
Are you asking were those statements made to her? I didn't hear the first part of your question.
Well, the coercion of the children may have been gone, but I'm asking about the coercion of having made a prior inconsistent statement when you're testifying under oath.
That
You
wasn't
understand
I
what
do
I'm
understand
saying?
that, but that wasn't the specific allegation.
Okay.
The specific allegation at the time was her testimony was coerced because she was threatened with these issues regarding her children. So that would insert a new angle into an already convoluted water.
But what, am I remembering correctly that she testified that her caseworker told her that her chances of getting her children back were increased if she cooperated or testified? I don't remember exactly what she said.
I believe that was at the preliminary hearing.
Okay, so that was before?
Yes. Because she specifically, if you could indulge me just a moment here. I don't see that in her direct testimony. I'm fairly certain that was at preliminary hearing. Yes, she specifically testified, volume 9, page 69, at the time of the prelim, my understanding was that if I cooperated with the state, that would help me get my kids back. And then she says right after that, the kids are not in my custody. And later on page 86 and 89 or 88, 86, she says, no, I did not get my kids back. I still don't have them. And then follows up on 88 on recross that the case involving my children is over. The defendant acknowledges that the district court's ruling does not encompass the pretrial statements, and most likely because that was something that wasn't raised. That isn't something that this court should take forward on appeal for the first time. The defendant argues that this is simply a question of law that this court can entertain for the first time on appeal, but in order to get to that question of law, we first have to have that factual foundation, and that factual foundation has not been provided here. If this court were to accept defendant's request and were to undertake an analysis of those facts, it would go through the same factors as you would with the defendant's voluntary statement: the manner, the duration, the fairness, her age, and her intellect. And when we look at her age, she was 21 years old. The duration of the interview was 4 hours, 15 minutes roughly. As far as the manner and the fairness, we have to look at it overall. We can't just focus on Officer Nagy's statements. There was no excessive force. The interview was professional for the most part. They made her comfortable. And when she was cold, she had a blanket. And when we're looking at the totality of the circumstances, and when we're going to focus on Officer Nagy's statements, then we also have to focus on the way Tamika responded to those statements.
How do we do that when the district court never did that?
Well, that's what I'm saying. I'm just saying if this court is
I
inclined to go down
I
that
understand
road.
if we get way down the road to
Right.
that point, the problem is that analysis never occurred.
Yeah, you can't do it, but just
Right.
for the sake of completion.
Right.
And if the court's not interested in going down that road, I completely understand. Anyway, the harmlessness aspect of it, to the extent the court disagrees and concludes that the court erred in declining to allow that testimony in, there's no reasonable probability that it contributed to the sentencing verdict. The jury still received evidence through other witnesses that testified at that resentencing, what the situation was like regarding Shavira's 2 days proceeding with the defendant, the substantial abuse that she endured, the suspicious circumstances of her disappearance, where the body was ultimately located, and the condition of the body when it was discovered. Defendant is not entitled to relief as a result of this issue. I would like to touch briefly on the sufficiency of the evidence regarding the aggravating factors relied upon by the state. Primarily, it's the state's position that it's really of no moment because the jury found there were 2 aggravating factors, that being the especially heinous, atrocious, and cruel. I believe that the jury is only required to find one. They're not required to find both.
What about the balancing?
The jury, in my mind, the jury balanced those mitigators against both. I don't think the jury balances as a collective whole. They balance against, do those mitigators balance against the especially heinous, atrocious, and cruel, and what is the effect of that? And those same mitigators balanced against the aggravating circumstance of the prior felony.
What do we have in the record that tells us that's how they go about it? Are they instructed to do them separately like that? Don't they just take the aggravators in one pot and the mitigators in the other?
But I don't think that it's a collective whole. They're told that these are the aggravating circumstances relied upon, and I would presume that since they are specifically or separated out, that the jury would consider each of them individually. Was this especially heinous, atrocious, and cruel, and was this and was the aggravator established that he had a prior conviction?
Yeah, I don't disagree with you that the jury would understand that it is supposed to evaluate the existence of each of the aggravators separately. I get that. I was just trying to get you to respond to your opposing colleague's argument about the balance is still a second step the jury has to undergo, and if you cut out one of the aggravators, the balance may weigh differently. That's all.
And I guess I don't necessarily agree.
I understand you
with
don't
that
agree, but is there something in the record that supports that?
There's nothing that specifically says what process the jury undertook, just that they found both aggravating factors and that neither was outweighed by the
And
mitigators.
so under your analysis, or the way it happens, the jury could impose the death sentence based on one aggravator, but life without parole based on another aggravator.
Well, we're not dealing with the death sentence here. We're talking about the hard 50.
Or
So
hard 50, I mean, saying, okay. They could impose the hard 50 on one aggravator and not on another. I mean, that makes no sense to me. We have one sentence we're dealing with, and so the independent balancing.
So I guess from that perspective, are you proposing that the state can only submit multiple aggravating factors? That
No,
there can never
I'm
be a single?
proposing that the aggravating factors have to be not outweighed by the mitigating circumstances. And that's what happens, is you do a balancing test to determine one sentence. And if you take one of the aggravators out, it changes the calculus. Or could change the calculus, at least it changes the analysis. And so I don't know how we can say, well, there was one anyway, so we're sure that that would have been enough.
I think we have to trust the process at some level. The jury is entrusted with the responsibility to weigh these mitigators. They're specifically instructed that they have to weigh these mitigators against these aggravators. I don't think that it's a collective whole, that they are required to find all in order to impose the sentence. To me, that doesn't make any sense. If they were to find that this wasn't especially heinous, atrocious, and cruel, then I don't think they're
But they
precluded
did
from
find
finding.
both of them. They
Yes.
did find both of them, and they weighed both of them against the mitigating circumstances. They didn't pick out individual mitigating circumstances. All of the mitigating circumstances did not outweigh the two aggravating factors that were determined.
And I absolutely agree with that.
And you take away one aggravating factor, and I'm asking you, how can we assume the jury would weigh the same way if there's only one aggravator versus 2 or 3 or 4 or 5?
Why-
It seems to me the more aggravating factors there are, the tougher it is for the mitigators to outweigh.
Why would they weigh any differently? It's the same mitigator. Does the fact that he's abused excuse the fact or weigh against the fact that this is especially heinous, atrocious, and cruel? Does the fact that he's abused weigh against this? I don't understand why it would be any different to view them collectively, and somehow how the weight or the impact of those mitigators differs when you're looking at possibly just one. You would go across and determine how that mitigating factor impacts that aggravating factor, not how this one mitigating factor impacts this body. You would have to look at them individually.
We just that's the problem. We just don't know that I mean, you're right. The jury might come out with the same result, but we don't have anything that would give us an indication that that is the case.
No, we don't have an indication that this is precisely the process that the jury undertook. The jury was instructed that they are to weigh mitigators against aggravators. I think it's fair to possibly assume, or to at least take into consideration, that they would follow that responsibility and look at each factor individually. Why would they not consider each factor individually? It doesn't make sense to me that somehow a single aggravating factor is given less weight than multiple aggravating factors, and somehow the balance shifts. If you were to give the jury the same instruction for a single aggravating factor, the process undertaken is no different than when
You don't think the state's case is stronger when it has multiple aggravating factors? Is that what you're saying? I don't understand that argument.
What I'm saying, I'm not saying that it's not any stronger. I'm just saying they don't undertake a different process. They don't just consider
Well, the
them
whole
all
reason the state
collectively.
wants to pile up the aggravating factors is because it's easier to meet the state's burden.
Well, I don't think the state is undertaking some sort of sinister approach.
I don't mean that it's sinister. I mean it's perfectly appropriate under the statute if you have the evidence to support it.
If you
But
have
that's
the
why you do
evidence,
it.
if you have the evidence to support the aggravating factors, then yes, absolutely, you should put them all forward. The jury is instructed there to consider the mitigating factors against the aggravating factors. It would be the state's position that that process is no different when there is one aggravating factor versus when there are 4.
Do you have any argument that would save the finding of the prior felony aggravator in this case?
Well, I think, yes. First of all, get to that portion of my argument. First, I would agree with Justice Rosen's position that the way that the statute is written, it specifically says that the defendant was previously convicted of a felony in which the defendant inflicted great bodily harm.
Is there any evidence that that is the case here?
Yes, there was evidence submitted through testimony that she sustained a gunshot wound, that she was required to seek medical treatment as a result of that gunshot wound. Detective Rose testified that that's the first place that he met her was in the hospital. So there is some evidence of great bodily harm. The state would also point out that, as we did in our brief, that in the defendant's original appeal, this court found sufficient evidence supported that prior conviction, which seemingly would conclude the matter. Now, to the extent it isn't necessarily binding, because that was kind of a unique circumstance in that you guys were making that finding so that it could be presented at the time of the resentencing. But we would nevertheless argue that the factors haven't changed. It's still the same prior conviction that was previously found to have sufficient evidence. If there
Isn't
are,
that the jury's role, though, to find that the evidence has been, the statutory evidence has been met, and the only argument that was submitted was, and it was basically an argument that nearly every gunshot wound results in disfigurement. Is that sufficient evidence to say that there was great bodily harm as a result of what occurred in the prior felony?
well, I don't think that was the only evidence that was
Well,
submitted.
shot in the foot. I mean, there's not any, we don't know much about what occurred there. And if you're trying to prove to enhance a sentence to 50 years, wouldn't it take more than just a statement that, yeah, I interviewed her in the hospital as a result of a gunshot wound to the foot? We don't know anything about what occurred there, if there's disfigurement, if there's great bodily harm. I mean, first blush, you get shot in the foot, yes, that would seem to indicate great bodily harm, but doesn't it take more than just seem to indicate?
Well, and I think we have to take the evidence collectively, because we also have a situation where Tamika's testifying that the defendant first pointed the gun in her face and then ultimately shot her in the foot. That I think if you're talking about a hospitalization and requiring medical treatment, I think it's going to require a little bit more than a mere grazing. And again, that would be the jury's determination to make based on all the evidence that's before them. And when they look at that collectively, hey, if she spent time overnight in the hospital, if she acknowledges that she was shot in the foot, then that would transcend normal bodily harm. It would not be a mere bruise, it would not be a mere abrasion, it would be something more substantial.
Counsel, I see you're out of time. Do you need 30 seconds to wrap up?
No, I would just say, if the court doesn't have any further questions, we would respectfully request that the defendant's sentence be affirmed.
Any more questions? Thank you, counsel.
I only have a couple of points on rebuttal, and I would like to initially preface this with the organization of the record is a little complex in this case with the remands and prior testimony, so I want to point out some of the sites I have here I believe are to the correct volumes, but I was regarding Justice Lukert's question involving whether or not this coercion was asserted at trial. My notes have that Ms. Loudermilk was questioned in volume 11, page 38. I think it's actually 37 to 38. About was her understanding from her caseworker, if she cooperated with the state, that would help you in getting your kid back, and her answer was right. So I believe it.
You believe that was at trial, not a preliminary hearing?
In my notes, I have that marked as at trial, and I think I said that in my brief. So I believe those statements were there. Although I haven't.
But the Sink case at trial was completed. That's what she said anyway.
I have not checked volume 9, pages 86 and 88, so I'm not sure. My recollection is that there was actually a hearing sort of at the start of one of the days of trial about a conflict an attorney had with her ongoing sink case. So I believe that that was ongoing at the time. My second point is a few times the state said that the burden is on the defendant to establish a witness's coercion. And I believe that, at least under our present case law, the burden is on the state to prove as with basically all suppression issues, once it's been asserted, the burden moves to the state to prove the voluntariness of the confession. Although I don't think there's been a case up to this date involving the statements that go into trial, whether or not the burden shifts. I know different states take different stances on that. Finally, the evidence involving the hospitalization of Miss Loudermilk for the gunshot wound, I believe her testimony was she couldn't recall if she had been hospitalized for it. And I think that goes to this final question of the sufficiency of her testimony, because at trial and then as it was reread at this sentencing trial, she had very little detail about what happened that led to this aggravated assault conviction.
Does it take her testimony? What about the officer's testimony? That's where he interviewed her, and that's what he understood that occurred, that she was shot in the foot and had to be in the hospital. Is that sufficient evidence to satisfy great bodily harm or disfigurement?
I don't think it's sufficient evidence to prove he had a prior conviction in which he inflicted great bodily harm.
And why not?
One, because he doesn't have a prior conviction for inflicting it, but two, because there's not enough to even tie that testimony to his conviction. And three, because her statements would be the only ones that would have a real perspective on her injuries.
And is his testimony specific as to whether she was interviewed after she'd been admitted to the hospital, or whether she was still in ER, or, I mean, what can we tell from his testimony?
From my recollection of it, it's very vague that he didn't recall very much about that initial meeting with her.
Do you have any further questions? All right, thank you, counsel. Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement. That concludes this morning's docket. Court is now in recess until 9 o'clock tomorrow morning.